All right, hi folks. This is Kurt Barone, and welcome to another edition of File Law Roundup. This time I am flying solo. I think I screwed up, and I thought Brad was on trial next week, but apparently he's tied up today and next week also. So I'm going to be handling it solo. Let me just get my audio worked out, but we'll go through the cases and probably be a little bit quicker than normal because there won't be any opportunity for back and forth. But first case is out of Colorado Springs Fire Department, and we had a suicidal man. Let me just kind of click on it, and we'll see the whole post here. But we had a suicidal man who apparently his ex-wife called in 911. The department, which it seems like they took a pretty proactive stance here in these types of things. They had a crisis response unit staffed with a police officer, a medic, and I believe a caseworker, social worker. And they responded, and apparently at some point they needed to restrain the man. He ended up passing away. And the lawsuit alleges wrongful death, some civil rights violations, contributing, I think, to some of the frustration on the part of the family, with some commentary that the medic apparently made at the hospital, kind of flippant, but I don't think people outside the fire service really understand sometimes that you say things as a way of coping, say things that if you knew you were being recorded, you probably would not say, but sometimes things get said. Apparently, some things that get said. The complaint has a lot more of the details that I'm going to really get into here, but there were some things that were probably inappropriate that he had said about what had happened, and at any rate, now we've got a federal lawsuit. Not clear on why, but the medic is no longer employed by the Colorado Springs Fire Department. He resigned. So whether that was over this or whether it was something else, but he's no longer employed there. So again, if I could just put an exclamation point on this particular case, this is representative of a trend I'm seeing. Very, very common. I've got somewhere over 140 cases now in the last few years, or 140 cases total, but 126 or so, 227 of them are from the last 8 years. So we're definitely seeing an increase in this. I've got an article going in Firehouse. I think it'll be in the April issue with the data. Now, the article was submitted a couple of weeks ago, so it's not going to include this case and several of the other cases that have happened since then. So the numbers are going up. My guess is that, civil rights attorneys are not just looking at police officers when these types of cases happen, but they're starting to focus their attention on us, which is something that they didn't do this prior to, I'd say, about 2016, which corresponds with the death of Michael Brown. So at any rate, we're pretty clearly in the line of fire when it comes to civil rights suits where either we have police assisting us, maybe with a mental health crisis, which is what we had here, or we're responding in because they've apprehended someone, and there are issues associated with that apprehension. So sometimes they're sedative related, ketamine related. Other times there's some asphyxiation issues or concerns about the way the patient was handled or treated. So unfortunate. Next one is something that I'm going to try to get Brad to come on maybe a 10 or 15-minute vlog just to talk about this one. I think it's really important, but it's something that has been talked about for the last 15 years anyway, but OSHA updating its standards that relate to the fire service. And there's a couple of ways they could have done it. They have traditionally had 29 CFR 1910-156, which is the fire brigade standard, primarily addresses fire brigades and fire departments in the private sector. They're not intended to govern public sector, but they have some things that are relevant. And generally, when OSHA applies to fire departments, they usually will use the general duty doctrine, which is basically a general duty requirement, which is that an employer has an obligation to provide a workplace that's free from recognized hazards. The thinking here goes that anything in an NFPA standard is a recognized hazard in our industry, and therefore a fire department needs to address that. So historically, they use the general duty doctrine to enforce NFPA standards. So now what they're talking about doing is upgrading the fire brigade standard. They're going to rename it. The new name would be the Emergency Response Standard. And it would incorporate either in whole or in part 21 NFPA standards, such as 1001, 1002, 1005, 1021, and so on. So many of the pretty much boilerplate standards that pretty much everyone complies with. But then they're going to go beyond that, and there's 14 other standards, including the flagship standard here, NFPA 1500, that they're going to be pulling certain parts out of it. And you can read it. I've got a link. If you go through the post here, I've got a link to review the proposed changes. So it's a very long document. I started reading it, and a couple hours later, I still wasn't down to the end of it. So there's an awful lot of blah blah blah, and I don't mean to trivialize it, but there's to the average firefighter, it's blah 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 information in it. I would recommend that you go right to the very bottom of the document. I'm not sure how many pages it is. It's not really, it's a HTML document, so it's really hard to figure out pages, but the final 20 or 30 pages of that document are the actual language of the standard. Okay, so that's, if you're interested in it, it has the potential to change things. And I know back when I was with the NFPA, so that would have been in 2010 when I left. There was some talk about OSHA doing this, and there was some talk that new standard that they were looking at would be basically an NFPA 1500 light, kind of like a light version of NFPA 1500. My quick review of that, it looks like that's exactly what they did. They took some of the important points out of NFPA 1500, pulled some things from other policies, other standards, and then made some of the core things like our PPE standard, SCBA, our training and all that, incorporated all of those in there. So the comment period ends, May 6th. Okay, so certainly anyone who's got concerns, and I joke here, you don't need to put them either here in YouTube or on my blog. I mean, I appreciate everybody who comments, but it's not going to do anything. If you have comments, if you don't like the direction that OSHA is going in, if you think they're not going far enough, whatever that may be, I would comment to OSHA. That's the way that you may actually produce some change. Again, not that I mind people, posting things on my blog, but it's not going to help. Okay, so if you want to really make a contribution to the fire service, I'd recommend that you post there. Again, just to clarify, I know there's a lot of confusion. It was something that was actually confusing to me back 30, 40 years ago when I first started practicing or studying law and then practicing law, what is the role of OSHA in relation to public sector fire departments? Federal OSHA has no jurisdiction over public sector fire departments. So you say, well, then what's the big deal here? OSHA does two things. Number one, they're responsible for investigating and enforcing health and safety standards in the private sector. But again, they enforce that. But the second part of that is they develop these standards, these industry-wide standards. Those standards in turn can be adopted by states. and the state can adopt it and basically say all municipalities, all public employees have to comply with the federal requirements. And there's a number of states, I forget off the top of my head how many states, but there's a number of states that have done exactly that. And so in those states, it's not going to be federal OSHA that comes in and cites a fire department. It's going to be the state OSHA inspectors or the State Department of Labor or whatever name that agency has. So again, this is highly relevant, and I think it's something that we need to be attentive to. It looks like they're headed in the right direction. I didn't see anything. I didn't study it, in the kind of level that if I had a client that wanted me to study it, I would. But my initial look at it was it doesn't look like there's anything unusual about it. It looks pretty good. Okay, so let's go to the next one. This one is an interesting case. I've been following it since the day it happened, but we had a firefighter in Connecticut, and he was assigned in his department as the PIO. And as the PIO, they had policies. The policy said, your job is to, go to scenes, take pictures, and, let the public know what we're doing. And that includes posting on Facebook and so on, within limits. Now, certainly, Connecticut is one of those states that has a law that regulates firefighters, first responders, and police officers from taking pictures. So at any rate, this particular PIO went to an accident scene, took some pictures, went back, posted them on social media. And according to his lawsuit now, there was a police officer that had a grudge against them for something that happened in the past. Now, whether that's true or not, we don't know. We'll leave that to the proof in the case. But at the end of the day, the PIO is arrested. He's charged. He faced charges, and he had these charges hanging over his head for 2 years. Didn't know if he's going to go to jail, get fined, get fired from his job, exactly what was going to happen. But his name was in the newspaper, and it created a lot of stress, unnecessary stress for him. At the end of the day, the charges ended up being dismissed only after his attorney said, we have a right to a speedy trial. Let's get to court. And the state ended up dismissing the charges. But the bottom line is, like, looking at the law, he didn't violate the law. And it's peculiar to me why law enforcement would have brought these types of charges. It's pretty clear by the reading of the statute that if you take pictures in the performance of your duties, or you share the pictures in the performance of your duties, and what is the performance of our duties? Whatever your policies say is appropriate for you to do. And in this case, it seems pretty clear that he was acting in the performance of his duties. These charges shouldn't have been brought. And you would think once an independent prosecutor looked at him, the charges would have been dropped. And then you would have thought once a judge looked at him, the charges would have been dropped. And none of that happened. It wasn't until he insisted on a trial that the case ended up being dismissed. So I think it's a really unfortunate situation. But at any rate, the PIO is now suing the police officers. There was a local police officer and a state police officer who's involved in his arrest. And he's accusing them, as well as the town of Montville, with false arrest, malicious prosecution, and a couple of torts, intentional infliction of severe emotional distress, and so on. So, unfortunate situation. I'm not a big fan of those laws. I really think laws like that Joshua's law, which prohibits photo taking and sharing, or limits photo taking and sharing by first responders, I think it's an unfortunate reaction to the failure of the leadership of police and fire departments to manage the digital imagery problem. We've got to manage that problem and address it. And when we fail to do that, the legislature, in response to public outcries, ends up handling it for us. And I think it's unfortunate. So, but at any rate, we'll see how that case comes out. The charges should have never been brought, and a lawsuit like this should not have been necessary, but it is what it is. Next case. This is a tough one, and I'm not sure I follow all of the the aspects of it, but we have a Philadelphia battalion chief who is suing the city, IAFF Local 22, Local 22's health plan, and Blue Cross, alleging that by denying her gender-affirming care and treatment, in particular surgery and so on, that by not covering that, they have committed gender discrimination. So the chief is not identified beyond the name of Jane Doe. And but apparently the chief has been a firefighter for 29 years, and otherwise has had a good career, no issues, and is alleging that the department and the union and the healthcare provider should be providing this gender affirming care. Okay, so we'll see how that works out. I'm not sure about what the precedent is there, whether or not that has to be provided, or whether or not it's optional. Last case here is it's an interesting case out of Illinois. We had a firefighter who had been with a certain department. He had been with he had been with the Lake Villa Fire Protection District as a career firefighter for, I think it was 8 years, or for 9 years. I'm sorry. No, I'm sorry. Let me get this straight. Okay, he served with the Wilmette Fire Department for 9 years. And he resigned on January 31st of 2020 and then took a job with Lake Villa. Okay, so sometime thereafter, and the complaint was not clear on this, but sometime thereafter, once he had left Wilmette and was hired by Lake Villa, he ended up becoming disabled. And it appears that it wasn't work-related. I'm assuming it wasn't work-related, but he applied for a disability pension. Now, he hadn't worked for Lake Villa Fire Protection District long enough to qualify for their pension, but he had worked long enough for the Wilmette Fire Department. You have to work, I think it's 8 years, if I'm not mistaken, it might be 7 years, but you've got to work a certain period of time. And he hadn't worked enough for the new fire department. So he said, oh, okay, then I'll go back against the old fire department because I worked there long enough. And they basically said, yeah, you worked here long enough, but you're not an employee anymore, and therefore you're not eligible for a disability pension. So that was the issue, and the case ended up making its way to the Illinois Court of Appeals. And the Illinois Court of Appeals pretty much agreed that, yeah, I mean, you're an employee of the Lake Villa, or you were when you applied for your disability. You were an employee of the Lake Villa Fire Department. You weren't an employee of the Wilmette Fire Department, and therefore you're not eligible for a pension from the Wilmette Fire Department. You have to look to the Lake Villa, and you don't have enough time in there. So interesting case. It's really statutory interpretation. The court is interpreting what the pension statutes say. So interesting case. I'm not sure it's really has much weight outside of the state of Illinois. And, in many states, like here in Rhode Island, many firefighters are part of the state firefighter pensions, so that you can get credit for your work in a neighboring department or another department when you get into the next department. And I think that's, there's some advantages to that. Also some disadvantages, which many fire departments are struggling with people leaving. They work there for a couple of years and then move on. And when you have independent pensions, it's a way of kind of keeping people in place so that they're not jumping around, whereas the state pension allows that. But here's an example of where it would have been beneficial to the employee. So, okay, so that's going to wrap it up. This could be one of our fastest fire law roundups for the week. But again, an interesting week. I'm going to try to get Brad to come talk more about the proposed changes to OSHA. I want to study them a little bit closer and make sure that everything in there looks like it's manageable for fire departments. Okay. And that's going to do it for another edition of Fire Law Roundup. If you would, please click like, like, please click share, and please subscribe if you haven't already done that. All of those things mean a lot to us in terms of getting our word out and, making the effort that we make to put this show on worthwhile. Okay. The more people that see it, the better it is for us. Okay. So thank you, and we'll see you again next week.